Vanakkam, the South Indian is here, and today we're going to speak about a topic which has been going on and on for many years. You talk about Tamil Nadu, yes, of course the Hindi imposition is one issue, but then this, what I'm going to talk about, this right now is something which has also been extremely controversial. Ladies and gentlemen, the contentious relationship between Tamil Nadu Governor R N Ravi and Muka Stalin's government. The slug-fest between a state government and governor, let me tell you, is not new. I am not trying to just cherry pick only Tamil Nadu. But then over the years, like I said, it has become unrelenting, particularly when we speak about three southern states, Tamil Nadu, Telangana and Kerala. Today, of course, we shall focus on Tamil Nadu, and in this case, there have been ideological clashes galore between the DMK government and Governor R N Ravi in the past over Aryan, Dravidian. You also count with me how Dravidian ideology is a dead ideology, whether to refer the state as Tamil Nadu or Tamilagam, how about bringing investments from abroad really does not help, making an oblique reference to Chief Minister Muka Stalin's sojourns overseas, the language policy, neat control of temples in Tamil Nadu, and the list goes on and on. For instance, on the NEET bill, which the Tamil Nadu government had vowed to get abolished in its election manifesto, Governor R N Ravi had said very clearly, and I am quoting him, "I am telling you very frankly, I will never give clearance to NEET exemption bill." Now, the government meanwhile said that the governor had positioned himself as a political rival who had caused a constitutional deadlock by simply sitting on the bills for months together. The matter came to head, and the government of Tamil Nadu finally decided to approach the apex court in, I think it was end October, to break this impasse. It filed a petition in the Supreme Court against Governor R N Ravi over the alleged delay in clearing bills. Now, 10 days after approaching the apex court, the Tamil Nadu House met for a special sitting on Saturday, called by the Speaker, and readopted all the pending bills, 10 out of 15. Even as Chief Minister Stalin slammed the governor for withholding the bills due to whims and fancies.
ஆளுநரால் திருப்பி அனுப்பி வைக்கப்பட்டுள்ள சட்ட முன்வடிவுகளை நாம் இங்கே மீண்டும் நிறைவேற்றி அவரது ஒப்புதலுக்காக மீண்டும் அனுப்பி வைக்க இருக்கிறோம். அவர் தனிப்பட்ட வெறுப்புகளின் அடிப்படையில் சட்டமன்ற பேரவையினால் நிறைவேற்றி அனுப்பப்பட்ட சில சட்ட முன்வடிவுகளுக்கு அனுமதி வழங்காமல் திருப்பி அனுப்பி வைத்திருப்பது என்பது தமிழ்நாட்டு மக்களையும் இந்த சட்டமன்றத்தையும் ஆளுநர் அவர்கள் அவமதிக்கின்றார் என்றுதான் பொருளாகும். 10 சட்ட முன்வடிவுகள் உள்ளிட்ட 12 சட்ட முன்வடிவுகள் மற்றும் வேறு சில கோப்புகளும் இவர் ஒப்புதல் வழங்காமல் இருப்பது சட்டவிரோதமாகும், ஜனநாயக விரோதமாகும், மக்கள் விரோதமாகும், மனசாட்சி விரோதமாகும். அனைத்துக்கும் மேலாக இந்த சட்டமன்றத்தின் இறையாண்மைக்கு எதிரானதாகும். தினந்தோறும் யாரையாவது கூட்டி வைத்துக் கொண்டு அவர் வகுப்பு எடுக்கிறார். வகுப்பு எடுக்கட்டும், தவறில்லை. அதில் மொத்தமும் தவறான பாடங்களை சொல்லி தந்து கொண்டிருக்கிறார். விழாக்களுக்கு செல்லுகிறார், செல்லட்டும். ஆனால் விதாண்டவாதமாக கருத்துக்களை சொல்லிக் கொண்டிருக்கிறார்.
Earlier, Tamil Nadu CM Stalin called for a special session on 18 November to adopt the 10 bills returned by the governor. These pending bills include 4 official orders and a file related to the premature release of 54 prisoners as well. The matter came up in front of the Supreme Court, and it came down extremely heavily on the governor, and the CGI said, and I am quoting him, "What was the governor doing for 3 years? Why should the governor wait for the parties to approach the Supreme Court?" And also, ladies and gentlemen, the court made it amply clear that it was not in any way picking only on Tamil Nadu, because on Monday the bench issued a notice to the centre on the Kerala government's plea against the delay by Governor Arif Mohammed Khan in considering 8 bills pending with him for periods ranging from 7 months to 2 years. Of course, the Tamil Nadu matter will yet again come for hearing in the first week of December. Now, the question is obviously more political. Let's be honest. Because the two parties belong to different political spectrums, ideologies as well as principles. Make no mistake about it. But then let us also look at the legalese the legal aspect involved in this drama which goes on and on between R N Ravi and Muka Stalin. Let's debate. I'm going to welcome the guest right now on my show. Satish Kumar, who is advocate with the Madras High Court, has joined us. K.V. Dhananjay, who is a senior advocate, Supreme Court of India, is also joined us. Salem Dharanidharan, DMK spokesperson. G.S. Prashant, who is spokesperson for the BJP. Vanakkam to all of you. Lovely to see all of you. You know, two aspects of it which is obvious. Satish, you and I have discussed the legal aspect of it, I think 2 years. As long as this battle's been going on, you and I have discussed this. But right now, if you quickly, Satish, tell me that calling a special session, do you think things have come to a head now? This is it. As in, you know, when you say that it's crossed all limits.
Exactly. Good evening to the viewers. Especially on this issue, what Tamil Nadu moved to the Supreme Court, to some extent, I would say that the move is going to give a clarity on the constitutional issue, which is stated in Article 200, of course. The Article 200 is not that much clear, I would say rather. Maybe the promoters or maybe the founders of the constitution, they were not thought that the country will face such an issue in future. However, our constitution is always elastic and flexible. That is the advantage of our constitution. So nothing wrong in amending if at all it is required, especially on the constitutional aspects. And this is only an administrative issue or a smooth functioning of the assembly, especially the constitutional authority or a governor and the state. The move of Tamil Nadu, especially to seeking an amendment in the constitution, I would say that there is nothing wrong in it. Yes, the Supreme Court can think that.
I'll come to Article. Satish, I'll come to Article 200, but I'm saying when you call a special session, you know, it obviously means that it is now the water has risen way beyond danger levels. Otherwise, why you, it's not like, you know, also it was this, the court has spoken. So I think, I do not know, maybe I'll, you know, do you think that it is now a stage where things have come to, like we say, a head?
No, I don't think so. I don't think so. I think the question raised by the Honorable Chief Justice was viewed so differently in a different version and different language. This is a normal question generally in a court during the course of arguments or discussion in the court. The judges, they raise questions. But I am quite little bit surprised in what context the Chief Justice of India has raised this question and how you
it is not, Satish, I'll come to a detailed discussion, but even the last time, while he was talking about the governor of Punjab, he was talking about the Kerala governor. Even then, he had used words which he is an honorable CJI. I will not say anything which goes against the honor of a court like that and a position of his chair. But he minced no words. He said, what about the people's rights? Time is wasted. Today, what he said, what were you doing for 2 years? What about democracy? He's used words which are people's friendly. I'll come to you. Prashant, I want to come to you. Prashant, my question to you, does it behove well for a governor of a state to make comments which reflect on the ruling government? I'm going to pick out two. One is foreign trade doesn't really bring investments. When Muka Stalin went abroad and said that we have been able to invite or attract investments, and also calling Dravidian ideology dead. I mean, come on, you're a constitutional head. If you keep saying I'm a constitutional head, then why do you interfere in politics, Prashant?
Sudha, firstly, you have to understand in what context the governor was making those statements, saying that foreign trips would not result in investments or whatever. Those will be his statements made in a particular context, and depending on the questions that are posed to him, or depending on which conference or audience he was addressing to. Because it might not have been necessarily to say that coming down heavily on the DMK government and said that Mr. Stalin, you're not supposed to go outside India and bring investments. No, I don't think that would have been the intention at all. And coming to the other important facet of the powers and the lines that have to be drawn between being holding a constitutional post and being in regular politics. I don't think in the present case it is a case of the governor misusing his position as a constitutional head to do an act which is politically sensitive, because given the state of affairs now, out of the 181 bills that was presented to the governor's office in the last 3 years, more than 150 have received assent. About 5 or 9 bills have been withdrawn by the government itself. About 15 bills were pending, out of which 5 or 6 have been tabled in October. Most of the 10 bills, which now is the matter of debate, pertains to some universities and other things where the governor, being the chancellor, is being challenged. So, governor necessarily look into it.
Prashant, first of all, I do not agree with you that the governor, I think, I've spoken to a lot of experts. Now, the thing is, either we politicize it or we respect the chair that he occupies. If the chair that he occupies has to be respected, and by all means, then let him not get into politics. I've just given you 2 examples. There are at least 20.
Sudha,
20
no,
examples.
What I'm saying is,
let me know. It cannot be let it be. Sorry, you can't say let it be.
Sudha,
Why are you saying
Sudha,
this?
Let me complete. Sudha, let me complete.
And all the bills that you said which are pending, which have to do with the university, they are saying, some experts are saying, because it will divest him of his powers, he is very bothered about it. Opening comments.
Need not necessarily.
Prashant, I'm coming. Prashant,
it need not go
please
with
wait
being
your
divested of
turn.
powers.
Dharan. Dhananjay, I see you also. Hello. I'll come to you. Opening comments, and then we can all debate, but no shouting. I mean, particularly today, I can't shout. My throat's gone for a 6, although cricket we lost, but my throat is kind of, like crazily bad. Selam Dharanidharan, I want to talk to you. That, what made the government to call a special session? Of course, the matter is in court. There are no 2 ways about it. But what is it? Some people are saying it's because your government doesn't seem to feels cornered just now. In the sense, when it comes to, there are corruption charges, there are lots of other things, and therefore, your government first wants to rid itself of this impediment called R N Ravi issue. Your opening statements, Selam Dharanidharan.
Vanakkam Sudha. Thank you for having me in your show.
Vanakkam.
It's very simple. In a democracy, who elects the MLAs? People elect their MLAs. MLAs are people's representatives. So why do they go to the assembly? To represent the voice of the people who have chosen them. So keeping that in mind, they choose an chief minister, and chief minister forms his council of ministers. So basically, whatever the council of ministers decide or the legislature decides is nothing but will of the 8.3 crore Tamil Nadu people. As simple as that. Right. So when governor is withholding assent to bills passed by the assembly or acting in contravention to the decision of the assembly, which means that he is disrespecting the will of the 8.3 crore Tamil Nadu people rather. So which means that he is acting as a blot to the democracy of this land. How can he sit on a bill for 3 years? Such gubernatorial procrastination is completely not acceptable. Right? Justice delayed is justice denied. So why are you not allowing us to function? The reason why he went to the Supreme Court is because he's not letting us function. Let's see, all this corruption is all this politics, ED. Let's go to what is the conviction rate of ED? 0.01%. So does ED investigation mean that party is corrupt? Absolutely not. 95% of the ED cases in BJP regime have been filed on the opposition politicians. And there has been 10 times more increase in ED cases in comparison to 2004.
The thing is, I get your point.
No important point. The same Governor R N Ravi has been sitting on sitting on permission to investigate ex-AIDMK ministers, now MLAs, who were actually investigated by the CBI and charge sheets were filed. In one case, I can say, is the Gutka scam. So they have nothing to do with politics.
That's why I want Dhananjay to put a kind of a prism on this. Dhananjay, this is what I said in my opening remarks. Make no mistake, this is more about politics. I mean, I have also lived through many years and, followed politics. I have seen slug-fest, but this slug-fest is the mother of all slug-fest, Dhananjay. So, do you think that there is a major part of it, the legalese part of it is very important, that's why you and Satish are here. But do you think a major part of it is to do with politics and legalese rather than the other way around?
Well, there is no doubt that what the governor is doing in several states where the opposition is in power, that is in fact not acceptable under our constitution. But politics aside, if you start looking at how governors have been partisan since our independence, you will find that governors, of course, have been partisan. The question is always of degree only. Until the S.R. Bommai judgment came in 1998,
Yeah.
it was that there were so many instances where the governors were recommending for president's rule, and that in fact, largely came down after the Bommai judgment of the Supreme Court. So now you have this new pattern of governors withholding assent to bills, which was never in the contemplation of our framers. Now, there is a suggestion that we must go ahead and then amend the constitution. But if you keep amending the constitution every time there is partisan behavior by someone, then the constitution will become unmanageable.
So what does it mean, Dhananjay? Then it's a kind of an impasse, right? I mean, it's an impasse. Now, I am asking you, if the governor is a constitutional authority only, I will not use rubber stamp and all that. I mean, it's really colonial. So, if he is a constitutional authority only, then under no circumstances can he withhold a bill, or he can?
Well, what happens is the governor acts as a nominal person only when he, in fact, assents to a large number of bills. That nominal position means that he is deprived of the discretion to either delay the matter or to ask unnecessary questions. Now, what seems to be happening is, in a large number of cases, the governors are simply sitting, still over these bills, over which they simply don't have the discretion to delay in that manner. And that is why the Supreme Court, in fact, has been making these oral observations. Mind you, the Supreme Court is yet to pass a detailed order on this aspect. All that they have done so far is to pass oral observations. And mindful of the fact that the office of the governor and the president is one where the courts generally tend to have a great deal of difference. So the courts would not even issue a notice to the governor, because if you do issue notice to the governor, then the governor would be duty bound to answer in the form of an affidavit, because the Constitution of India, Article 361, gives a kind of immunity to the governor and to the president. Courts in this country, that is the High Courts and the Supreme Court, would not even issue notice to the governor or to the president.
Okay.
So given that position, the Supreme Court's oral observations will tell you that the Supreme Court is taking this matter so seriously that they absolutely see no justification for any of the governors to withhold assent to the bills.
Absolutely.
Now, it's important.
Yeah, Satish, there you have the answer from a fellow advocate. You know what the Supreme Court has said, and I do not know, but I have read, what Singhvi said, what Wilson said. I was reading it, Dhananjay, and I think the court has made very strong observations. Their observations being about wastage of time, their observation being rights of the people in a democracy. And Satish, I want to ask you this for the benefit of the viewers. How many times can a governor actually send a bill to the president for consideration? I mean, if whoever is the honorable president of this country, if I am the governor, I can't keep sending it for assent, then it comes again, then what is this? I mean, this is not a kind of a relay race, right? There has to be some limit on it. Would you agree?
Sudha, basically we should understand that why the governor is sending the bill back, and he sends the bill always with a message. That message has a meaning in it. See, if the government really is looking out for what reasons the bills have been sent back, the government is bound to rectify it. See, in this case, especially on the 10 bills issue, I don't want to go into the facts of the case, because the 10 bills totally, according to the governors, according to our understanding also, it is unconstitutional, because changing the powers of the vice chancellor and all those issues are there. That is, according to the governor's stand, it is unconstitutional. Hence, he is sending the bills back. And it is in case of an amendment, I am telling you very clearly, in case a small amendment or rectification is required, then it is, the governor can give a suggestion for corrections. But in this case, especially on the 10 bills, it is not a matter of suggestion. The entire bill itself is unconstitutional. For that only he is sent back, and with a message. It is the fact is very clear.
What is unconstitutional?
Such bills cannot be passed.
Selan, Dharanidharan, come in. What is unconstitutional? I mean, what is unconstitutional about these 10 bills? Dharanidharan, go ahead, unmute yourself, please.
There is nothing unconstitutional in these bills because Gujarat Assembly, when this now Prime Minister Modi was the Chief Minister, have given the then Governor given assent to these bills in which the Vice Chancellor could be directly chosen by the Chief Minister. I'll also tell you why it is not unconstitutional, because who funds the Tamil Nadu universities? Money of the Tamil Nadu taxpayers, right? And who gives the mandate to the Tamil Nadu government to enact legislation? People, because people have voted DMK government to power. So, and this was even some bills from ADMK regime are now pending. So, who is he to sit on those bills? See, we follow Westminster system, right? See, like investment in England, they follow the same system. Who's equivalent to a governor, president there? King or the queen? So, ever seen a king or a queen, the crown rather, not giving assent or withholding assent to any of these bills in the last 300 years? It has never happened in the British democracy.
No, but that I will not agree. British, that's a monarchy.
Come out of the colonial mindset.
No, I will not understand. I will not agree to that. That's a monarchy. No. We are a different nation. We have a different constitution. What is this? You can't say queen, king. I mean, the kind of thing. Maybe we have thinking governors. No, Dharanidharan, that's not fair, Dharanidharan.
Let me come in.
I can add on. See, as a student of political
just
science,
a second, Prashant.
University, I know constitutionality. Right? I understand how these things are decided. You go and ask any political scientist, leave politics apart, the constitution is the same, and the power which the king or the queen has is the same that has been given to the governor. That is, he has only duties, no functions.
Okay, fine. Prashant, come in. Prashant, please come in, Prashant. Prashant.
Yes. So, firstly, let my spokesperson representing DMK answer whether Britain has got a written constitution. So, let's not get on to whether the king and queen is supreme. They don't even have a written constitution. So, let's not get on to the British system. They have to come out of this colonial mindset. And now coming to Article 200, the second proviso to Article 200 is very clear that the governor, when he shall not assent to, but he shall reserve for the consideration of president. So, it means at any point in time, when the governor does not want to give assent, and also he has the power to reserve it for the consideration of president, because there are 4 limbs in Article 200. One, he assents or he withholds or reserves the bill for the consideration of president and returns the bill with message. So what has happened here? He has initially returned the bill with a message. Then they have convened a special session only for this. We don't know how many times the DMK government would have convened a special session to ensure that people get all the
but there is a limit also. That's why I want to bring Dhananjay here. Dhananjay, I want to bring you here that it is said during that whole conversation, Dhananjay, Article 200 does not mean the governor withholds bills and there is no reason attached to it or no due application of mine. You know, the thing is that there has to be these two things, and once suppose I am the governor and I send the bill back, let's say the second time over, I cannot possibly announce that, oh, this bill is dead. R N Ravi has done it also. Dhananjay, can I have you on the screen? Can Dhananjay come onto the screen?
I am on the screen.
I can't. There, I see you now. Oh, I didn't see you for some time. Hi. So, did you hear my question, Dhananjay?
I
Please
heard
go
it
ahead.
today.
Please go ahead.
Well, the governor can make inquiries, and those inquiries are confined to whether the procedure laid down in the constitution have been duly followed. Now, for instance, if the governor is presented with a bill on the claim that the majority has assented to it, but the governor knows that someone does not have a majority or the governor doubts the existence of a majority, then that is a matter where the governor has a doubt over procedure. Now, short of that, if the government were to tell him that the procedure for passing of a bill is XYZ, we have complied with XYZ, the governor is not authorized to conduct his own inquiry. The governor simply will have to assent to the bill. And that is the reason why I did say in the very beginning that the governor's satisfaction in assenting to a bill is only of a nominal nature. Now, if the governor believes that the bill, if passed, could become unconstitutional, then the governor simply can't substitute himself for a due court of law. If there is going to be a bill which eventually would become unconstitutional because the law that it brings out is unconstitutional, why else do we have the High Court? So why else do we have the Supreme Court? And an affected party will move the court and get an appropriate declaration. But the governor to develop himself as a court and then say that should he assent to the bill, then the bill will be taking the form of an unconstitutional law, is the governor overstepping his authority. The constitution clearly defines the role of the governor, and the role of the governor largely is nominal. There are some areas where the governor will not be bound by the advice of the Council of Ministers, but we are not even dealing with those cases.
Yeah.
So, if
So
a
in
bill
this
is
case,
presented,
Dhananjay, in this case, I know that the Supreme Court has spoken and maybe you wouldn't, but if you wanted to, would you say that in this case, Tamil Nadu Governor R N Ravi has overstepped his constitutional authority and powers?
I think so, number one. Number two, the
Okay.
Tamil Nadu government also has to be quite considerate while talking about a governor, because if the Tamil Nadu government, in fact, does something like demean the office of the governor by using intemperate language, then I think that also should be taken to task by the Supreme Court, because the Supreme Court is not just dealing with grievance on one side. The Supreme Court is also hearing on grievances from the other side as well. I think the governor is mildly justified, but not justified to the extent that the governor's office claims. The governor, no doubt, is very mildly justified because the governor wanted certain clarifications, which
Right.
apparently did not come from the government. Number one. Number two, the governor being given the authority to appoint vice chancellors is a matter over the states have the power to make laws, and if
Yes.
the states are unhappy with how the governor is making those appointments, the states have, in fact, the prerogative to simply cut out the governor,
Right.
and the governor should be the last person to delay, assent to those bills.
So
The
there
governor
you
should
have it.
simply-
Dhananjay, very well. There you have it, Satish. There you have it. It's so clear cut, because I recall that once talking to you and also to other luminaries who said the governor can take as much time to sit on a bill. There is no time limit. Now, I want to ask you that it's very clear. He is a nominal figure. If he sends the bill back to the president, it has to be attached with a legitimate reason as to why the bill is being sent. But you can't inordinately sit on a bill like that and also give kind of, very tenuous reasons for the delay.
Sudha, here the question what you are asking is to some extent I accept, because unfortunately our constitution is not giving a clarity on as early as possible. The definition of as early as possible is not clear in the constitution. Similarly, the meaning of withhold is still in question mark. I accept, and I say that the question of Tamil Nadu government in asking fix a time frame. Yes, it is the time now. The time has come for fixing a time frame for giving whether to assent or send the bill or holding the bill. There is a time frame is required, which I have no second thoughts at all. But at the same time, you should think, if the amendment comes, the Supreme Court can only give a suggestion or maybe a finding or observation to the Parliament for amending the constitution. That will go only to the Parliament for amending the constitution in this regard. And our constitution is very flexible, because when the constitution came in 1950, 51 itself on the very next year got amended. So amendment to the constitution has no restriction at all.
Yeah, but thank
if it is
God,
reasonable, I'm coming to that point.
Yeah.
I'm coming to if at all such amendment is made, and the suggestion or advice by the Supreme Court may also give for even to reject.
Right.
Even to reject, because there is no such word clear. Instead of reject, the constitution has used the word withhold. Please understand, withhold means indirectly reject.
But withhold for how long? You can't keep withholding it till the cows come home, right? I mean, the constitution could be flexible, but the constitution cannot be possibly be open-endedly vague on this. The vagueness of it is what I'm talking. And Prashant, I was coming to you. Wait a minute.
I'm saying there is, if at all, now the time has come, because our constitution is flexible. Amendment, if at all is required, can be done. Time frame can be fixed.
Prashant, Dharnidharan, I'll come to you. Prashant, I want to ask you. After all, the people of this country vote in a government, right? What about all this wastage of time? 2 years has gone by. Forget NEET, fine, that's a different story. But any bill, forget universities, chalo, we'll take that out also. Whether it's release of prisoners, whether it's our other orders, you think my money that you are using, you meaning politicians are using to run the government, run the state as it were, so much time should be wasted. I mean, I've seen in Karnataka something which has to do with roads and everything that was delayed also. In Telangana, it is the same story. In Kerala, Arif Muhammad Khan and the Pinarayi Vijayan slug-fest is also legendary. I want to ask you only from the people's point of view, Prashant sir, why don't you answer this? If this goes wrong, the court will have to intervene. But ultimately, who's losing time, sir?
Sudha, firstly, there are many taxing statutes also in which when time limits were not prescribed, or when the law was that the orders have to be passed within a reasonable time, Supreme Court has stepped in the case of Mahindra and Mahindra also, coming back and saying a reasonable time frame for passing of orders when there was no reasonable time frame fixed was 4 years in a taxing statute. So therefore, even in taxing statute, when Supreme Court has stepped in and given a time, Supreme Court has got all the powers to say we are fixing a reasonable time frame of say 1 year, 2 years, 6 months, whatever, depending on the case. So definitely there is I would not say lacuna, there is a shortfall in terms of exact timelines. There is no timeline prescribed under Article 200. Therefore, this particular issue has reached the Supreme Court. Now, Supreme Court very well, I am sure Mr. Dhananjay also will agree with me, has the power under Article 142 to come back and say, look, we are going to have this and have a reasonable time frame fix, which they have done in the past also for the Maharashtra
Right.
Speaker.
So far,
also,
I'll be honest, so far, I think, Dhananjay is what I would call very people's friendly. I'm sorry, all of you have spoken beautifully, but I'm only looking at it from the people's point of view. And Dhananjay says this inordinate delaying of bills, I mean, you can't do it. You are a nominal figure. You have to look at the bills. Of course, you can protest, when there is a bone of contention, but you can't possibly sitting on so many bills. I mean, 15 bills could be equal to so many man hours wasted. And also, what will come out of this entire political slugfest, I say? After all, DMK has to go and fight the election amongst people. They are not fighting an election with R N Ravi. Go on, Dharanidharan. Please go ahead, sir.
I think first, I'd like to say two things. The first, with regards to inordinate, the time duration, Mr. PDT Achari, former Lok Sabha Secretary General, written a couple of beautiful editorials in which he clearly says that the framers did not choose a time frame because it was understood, self-understood that bills should be cleared and acted upon as soon as possible. Either he clears it or sends it back for reconsideration or send to the president as soon as possible. The framers did not think that people of low morality will occupy the house, that you have to specifically mention. Certain things are not mentioned.
No, you can't make
right?
statements of low morality.
What is this low morality? Who is low morality?
Not about the constitutional debate. One second, let me had the final say.
I shall expunge your statement, as they say. What is low morality? I think you cannot use these terms at all.
I never said it's of low morality. I said that
you
never
use it now.
expected people of low morality
you used it now.
That's all. Try to sit as long as possible because it's travesty of democracy and travesty of justice. When people have spent so much money to conduct election and elected government comes to power, and then you sit on the bill for 3 years, 4 years. How is it fair? Then why have democracy? Why
exactly
have
what the CGI said, Dharanidharan. He said, what was he doing for 2 years? The Honorable CGI did say that.
Yes, exactly.
And I think what I liked about the entire observation is I am not someone who understands legalese. But there is one thing I understand is people's, the way judiciary interferes or people call it intervenes rather to make it more people's friendly, and that's what is very important here. I don't want to get into this dirty politics all the time.
Yes, one more point. Can
quickly.
I add on?
Sudha, just quickly.
Ambedkar had the last word on constitutional debate when it comes to governor. He clearly mentioned it, that they have only duties and no functions to perform. And that is why it was decided that there will be no elections to elect a governor, because if there were elections, either direct or indirect, he may interfere with the elected government, which has been in concurrence with all the Supreme Court judgment as recent as Pererivalan, where Justice Naheshwar clearly
Dhananjay, I'll come to you, Prashant. Dhananjay, I want to come to you, Dhananjay. What is the way out now? They have called a special session. The court has also spoken now very, very strongly. Of course, there are a battery of lawyers from both sides saying that this is because of this, that is because of that. Tell me, if you were a citizen if you lived in Tamil Nadu, denizen of Tamil Nadu, what happens? What is the recourse? Suppose one bill actually impacts you. What does one do?
Well, I would expect that the governors would in fact do whatever it takes to make the a matter before the Supreme Court go mute. It's not in the best interest of this country that the Supreme Court will in fact say that there should be a rule that the governors will act in 21 days or 30 days or so. As much as the Constitution does not say within how many days the Supreme Court will have to decide a matter, because the Constitution, the framers knew that only men of integrity, men of honor would occupy the position of judges of the Supreme Court. So similarly, the Constitution assumes that men of great honor will occupy the office of the governor, and it would not be befitting their role to in fact lay down a rule and say that they should do everything within 21 days, they should assent to a bill within 30 days or 45 days. I say this because when you look at the long term, it would be below the office of a governor to point out at him and say that, look, you have 25 days to do this, you have 15 days to do this. So the governors, I think, should in fact, do whatever it takes to get that grievance out of the Supreme Court. It's not in the country's interest that the Supreme Court intervenes in this matter and then curtails the power of the governor by saying 20 days or 40 days or so. We want the governor's office to be one, even above honor, and we don't want it to be curtailed in this manner.
Satish, tell me something. There are also experts who are asking that can a governor withhold bills after they have been passed? I mean, they've compared it to a money bill. This, for the viewers, I mean, if that be the case, then what has R N Ravi been doing, I say, for all these days?
No. In case of money bill, it's totally different. He has to give his accent because that is a different case. So I don't want to come to the money bills. Let us come to the non-money bills especially. And what at present at this juncture, they are asking for a time frame. Even I agree with Mr. Dhananjay that some sort of time frame has to be fixed if at all is required. Yes, time frame can be fixed. There's no doubt. At the same time, governor has to be given a transparent or even an open power even to reject the bill if it is considered to be an unconstitutional, or there may be some other via media by which he can refer to the president to verify out to the legal team of the law ministry, or maybe even to the parliament to some extent. Some sort of via media has to be made.
Can a governor withhold bills after they are passed? You are saying yes, he can. Is that what you're saying?
No, I'm saying he can withhold as of today because the powers has been given to the governor to withhold. Withhold, if it is done within the time frame, it gives the meaning of the word withhold. When it says the time is unlimited, it indirectly means it's reject.
But as of now, it is unlimited. So does it mean rejected? I find this entire thing exactly like what Governor R N Ravi said. It's dead. How is it dead? The House has passed it. Now you don't accept it. You have a logical reasoning. You send it to the president.
You mean to say that if the assembly passes a resolution which is unconstitutional, an authority of the constitution?
No, I don't mean what is this? I didn't say unconstitutional. Only thing is that there is a bit of.
That's what.
There is lack of clarity. Prashant, go ahead.
See, coming to the aspect of what the framers of constitution thought, men of integrity will. Yes, definitely. And the same constitution under Article 61 and Article 137 also provides procedures for impeachment of a governor, impeachment of president, if they have not followed the constitution or if it's a violation of constitution. Therefore, the framers of constitution have very well thought out that even any person who occupies a constitutional post, if they have violated the constitution or acted in contravention of that, have procedures in place for impeachment of president and governor also. So therefore, to come back to the saying that in Article 200, governor definitely has got the power to withhold his consent, and also second time also he can withhold the consent and send it back to the president for consideration. And thereafter, once it is sent to the president for consideration, it need not come back to the governor. The president can decide on its own. Article 201 is very clear on that.
No one is saying that the governor does not have the right to withhold. But I have a problem, and I think Dhananjay put it very well. You cannot have unbridled power and unlimited time. This is not something which goes on and on. After all, governors will come and go and chief ministers come and go. So I don't understand. If there is clarity which is required, then I am sure the honorable court will step in and clarify this. As of now, it seems that this slugfest has wasted a lot of man hours of people who live in Tamil Nadu and also the taxpayers' money. So it needs to get solved sooner rather than later. Thank you very much, Selam Dharanidharan. My thanks to Satish. It is always such a pleasure, Prashant. Thank you very much, Dhananjay. pleasure. Thank you very, very much for joining us on this debate. So, even as we are talking about this slugfest, which is going to continue between the Chief Minister of Tamil Nadu, M.K. Stalin, and Governor R N Ravi, I hope not. The South Indian shall move to another story, but in a bit.